Szanowni Państwo, nazywam się Anna.
Ladies and gentlemen, my name is Anna Wójcik and I'm happy to welcome you on Sunday debates of the Freedom Games. This debate will be on the condition of the rule of law in Poland in 2020. I'm going to present the panelists, the Commissioner for the Protection of Civil Rights, Mr. Adam Bodnar, Kamila Gasiuk-Pihowicz, who is an MP, Professor Trela, who is a professor at the University of Łódź, and Professor Sadurski, who is a professor at the University of Sydney and University of Warsaw. The book by Professor Sadowski was published in 2018. It was published by Oxford University Press, and this year it was published by Liberté, and it will provide the basis of today's consideration. Since 2015, Poland has suffered changes in terms of courts, problems between executive, judicial and legislative authorities. So at which stage are we with these changes in 2020? So since the 22nd of October, we are talking about the role of the Constitutional Tribunal in this new system. So, Professor, the floor is yours. I would like to thank the publishers, the Liberté Foundation, for publishing the book. I would like to say thank you to Anna Wójcik for great translation, for great cooperation when I was updating the book. There is a catalogue of terms used to describe such systems as the system we have in Poland. We hear about non-liberal democracy, so on the one hand we've got free election, on the other there is no guarantee that the rule of law will be maintained. But this is an oxymoron. Democracy has to be based on fundamental rules and freedoms, and any other systems cannot be regarded as democracy. We are talking about a hybrid system, but it's not clear enough. The hybrid, it means that this is this kind of a system to a lesser or greater extent. And we have observed in Poland that we neither have a stable, consolidated democracy, nor full despotism. So in my opinion, to define the system we are witnessing is authoritarianism, populist authoritarianism. So these two terms are important in this name, and they play different roles. This is an authoritarian system because in the Polish system we are already lacking two fundamental requirements for the democracy. We are lacking the real division of authorities. There is dispersed authority that currently almost the whole authority is focused in the hands of one party, because if the leader of the ruling party decides to leave his active political life, then we have no doubts that we will have the continuation in the ruling party. There's also another requirement that is not met, that is the rule of law. That the government is amending the law, developing the law, but they are not. They are only amending the law when some amendments are needed. They do not observe the constitutional law. So to change this law, to amend the constitutional law, some preconditions have to be met. So we have some democratic elements. We've got some democratic elements. There is free press, free election to a certain extent. The last elections have been fair to a certain extent. So we have noticed that that actually lots of the state resources spent to organize the election to meet the requirements of the government. So there is the rule of law. It's also a populist system. So populism can be perceived as a discourse that concerns, for instance, xenophobia, or there is also populism that is a kind of a social system to meet the immediate needs while ignoring structural changes and providing public goods. I mean the system-related populism. The distinguished American constitutionalist Samuel Sakharov, he calls this kind of policy as the policy of the sudden changes. So the government is expecting that if they want to introduce some changes, they will demand institution to follow the orders. So, for instance, we can consider courts. The courts should be independent of the ruling government. We should also have the independent institutions such as the National Bank. So either these entities already follow the orders of the government, or they are in the progress of adapting to the requirements of the government. So when we are looking at this kind of democracy, we can see some leaders that are taking quite a lot, and in Poland, the government wants to take everything. So this is why, also in my book, I'm writing about this. To me, this system in Poland is the populist authoritarian system. So let's focus on one of the key institutions, that is the Constitutional Tribunal. I wanted to ask Professor Anna Rakowska-Trela, what is the role of the Constitutional Tribunal during the reign of Jarosław Kaczyński's government? Thank you for the question. I think the answer to this question will be quite sad. I would prefer to talk about a different role of the Constitutional Tribunal. Let's start how the Constitution perceives this body. To use a simple language, Constitutional Tribunal is a body, it's a judicial authority that guards the constitutions. It's a different context than that president's role. The president should also guard the constitution, but the tribunal is a court of law and it decides whether specific acts are in line with the constitution or not. We can say that this tribunal is a kind of a negative legislator, regulator. So the tribunal should reject these acts, these proposals that are not in line with the Constitution. So the tribunal should delete the rubbish, constitutional rubbish, so the acts that are not compliant with the Constitution. How comes that the tribunal has this competence? Firstly, the tribunal, or the judges of the tribunal, should be independent, and the Constitution introduces some specific standards long term. The judges are protected by the immunity, that they receive remuneration, and they should be not politically involved. Being professionals, this is another feature. These people should be should be distinguished lawyers. And the third characteristic, which causes quite a lot of problems, authority. The authority of the Constitutional Tribunal as the institution and the authority of the judges. So this authority should result from the professional attitude, from their personalities, and also they shouldn't be involved in the political disputes. So what have we got during the current situation? So only the constitutional regulation has remained. All the personality-related elements that should determine the authority of the tribunal, that the tribunal should be able to deliver its competence without any interference. This is no longer existing. So now it's time to answer the question, so what happened to the tribunal after 2015? In my opinion, well, it has become a notary of difficult decisions of the government. The tribunal has become involved in the political disputes. It has also lost its professional nature. The government probably the government is right. So the government thinks that if there are some blames concerning constitutionality, they should approach the Constitutional Tribunal, and the tribunal will issue a verdict that will meet requirements, needs of the government, and that it will eliminate social disputes. So the authority of the tribunal will be used to emphasize the accuracy of the government's policy and its compliance with the constitution. But I don't think it has actually happened, because the society has noticed that there is something wrong with the tribunal. It is evidenced by the protests that have started when the Constitutional Tribunal issued its verdict, but the crowd didn't go to the tribunal. They went to the house of Jarosław Kaczyński. So the society has noticed that tribunal is no longer independent authority that enjoys accountability and trust. So this authority has collapsed, so the tribunal is no longer the constitutional tribunal. There are lots of controversial issues dealt by the tribunal. They are political decisions. So, for instance, its term of office of the Commissioner for the Protection of Civil Rights. These are the problems of appointing judges. There were lots of applications by the National Council of Courts. There was also the issue of changing the dates of the presidential election this year. We also had the competence dispute between the Supreme Court and the Parliament and President. So these are all political affairs. So we can foresee what kind of decisions will be issued, if they will be, if any decisions will be made at all. So the tribunal should really decide whether these acts are in compliance with the constitution or not. Thank you.
Unfortunately, the protests have recently shown how the irregularities of the Constitutional Tribunal could affect people's life. So my question to the Commissioner for Civil Rights Protection, if we have so many doubts concerning the independence of the Constitutional Tribunal, could European courts come into rescue to help us restore the rule of law? Thank you very much for inviting me to participate in the discussion. I still have the opportunity to be in the position of the Commissioner for Civil Rights Protection, the Ombudsman, for 2 more weeks. Perhaps what I'm going to say will not be clear for everybody, but I think that because this is Freedom Games, we have to explain at what stage we are when it comes to the proceedings in the European courts. First and foremost, it is important to lead to the accusation of the act in the European Court. Now the European Union has passed to the stage of explanation, and they have 2 months to express their opinion. Vera Jourova was in Poland in January, and in the middle of November we are on the stage when it is not, when the case is not in the Court of Justice of the European Union. Until the Court of Justice of the European Union passes an opinion on the disciplinary chamber, it still has the right to issue its sentences. It applies to to the court, to Mr. Juszczyszyn or Mr. Tuleja, who are the judges. Furthermore, it issues an opinion to cut the remuneration by half. In my opinion, it is not acceptable to interpret it in such a way that the temporary decision of the Court of Justice is limited only to the disciplinary proceedings. It should be interpreted in such a way that the disciplinary board should not issue its sentences, and the application for fines issued by the European Court of Justice should be imposed. The proceedings which are in the European Court of Justice, we're going to have proceedings in front of the European Court of Justice. The media should focus on that, and furthermore, we should remember that on the 17th of December and in January next year, the opinions shall be issued related to the jurisdiction. The opinion of the General Chairman confirmed the previous judicial of the European Court of Justice. However, it seems that a report should be developed on the arrest warrant, of the European arrest warrant. The number of cases which have been communicated to the Polish government applying to the systems of proceedings and depriving the judges of their positions in the National Justice Board should be completed. This applies to Judge Tuleja or Judge Żurek. It is a perfect example of what is happening issuing decisions. It applies to the decisions of the courts, to adjudication. So we don't really know what the Strasbourg Tribunal is waiting for. Talking about the disciplinary board of the Supreme Court, the proceedings should be carried out also by the European Court of Justice. We are also waiting for the decision of the Supreme Chamber. The Tribunal is aware of the fact that this is a very important system for a very important case for the whole system. 9 months have passed since the proceedings was carried out. I applied to the Minister of Foreign Affairs, and perhaps they will issue the decision on the rule of law. We also need to remember that the problems with the rule of law have consequences for many people. The good examples are the sentences, the decisions of related to LGBT. They will soon go to the Supreme Administrative Court. I don't have to present the person of Judge Piebiak. If the nomination procedure and the competition procedure is completed, we'll soon have the situation when the Supreme Administrative Court will no longer be independent. We are also going to have the visit paid by the monitoring commission. The procedure, the commission should focus not only on the courts but also on the prosecutor's office and public media. It is about coming back to different recommendations of the Venice Commission. It issued the opinions not only on the courts but also special services, prosecutor's office. They have been ignored, but we as the people following what is happening in Poland should not forget about it. Thank you very much for the opportunity to deliver my speech. Thank you. Your presentation showed that since that it is as if we were writing a book about the constitutional fall of in Poland. We have so many actors and so many plots that it's really hard to capture it and understand it even if you are interested in it. Question to Ms. Gasiuk-Pihowicz. Something has changed because even people who are not interested in politics went to the streets requesting that independent courts and the rule of law are restored in Poland. The sentence of the Constitutional Tribunal on abortion showed to the people that this complex process affects their life and the sense of dignity and safety in the state in which they live. So my question is, what do politicians think about the mass protest? Because this is like a democratic uprising. It shows that in Polish democracy we have a lot of people who have a positive attitude to the authoritarian populism, but also people who require a different form, require democracy. What would you say? Thank you very much for this question. Recent weeks have clearly shown what extreme political stance of the Constitutional Tribunal may lead to and what consequences it can bring. COVID is a perfect shield covering the attempts to limit citizens' rights by the law and justice, and they are doing it step by step. The pandemic is extremely dangerous, not only for the life and health of humans, but also for Polish democracy, for the Polish state of law. We are in a situation when our country is on fire, and in the meantime, law and justice is stealing our democracy. We have seen it from the beginning of the pandemic. We have had some amendments implemented in the criminal code. For instance, attempts to close people under home arrest. This was the idea of prosecutor Ziobro. We also had the mail voting, and then followed by the pandemic helped the ruling party implement some actions of the disciplinary board. Many of these actions were accelerated, such as the one towards Judge Morawiec. Next month we are going to have the hearing referring to Judge Tuleya. In autumn, an attempt has been made to take over the office of the Ombudsman, of the Commissioner for Civil Rights Protection. Definitely we'll soon see a person appointed by Law and Justice in this position. The pandemic provided a perfect shield for law and justice to use the tools they have been developing and building for many years. It tried to reach into the Constitutional Tribunal by issuing the opinions that are then decided upon by the Constitutional Tribunal. For a few months now, we have had a flood of applicants to the Constitutional Tribunal. Professor Trela greatly summarized the role of the Constitutional Tribunal. I can see three functions that the tribunal fulfills. We have heard about money laundering, so I know this is like a mafia comparison, which Professor Sadurski once suggested. We have all heard about money laundering, and this comparison could be used in reference to the Constitutional Tribunal, because in the current in its current form, the tribunal has become the laundry of acts. So whenever law and justice has such a need, they can be sure that the tribunal would accept the act which perhaps is not according to the law. The second role that Jarosław Kaczyński has for the tribunal is related to using the tribunal as the legal freezer for some regulations, and it applies to the Istanbul Convention. Another role of the tribunal we have observed is the role of the role and justice servant. We have heard and we have seen the attempts to change the abortion law, and it was also done with the hands of the Constitutional Tribunal. So the last role of the legal mercenary of the law and justice was finally used. The politicization of the Constitutional Tribunal we have discussed here was like a clock bomb planted under the Polish state, and it exploded on the 20th of October, contrary to international obligations, regulations, laws, and acts. Contrary to common sense, Ms. Przyłębska decided that Polish women are supposed to give birth to lethally ill children. It is like legal sadism. That's the way it should be called, because the state which forces you to give birth to lethally ill children is no longer a friendly state. This is the executioner, the torturer. There is nothing more terrible than making the parents, than depriving the parents the right to make their own decisions and making them look at their ill children. The emotions have skyrocketed and reached its peak. Even the fact that the protests are organized in towns, in villages, show that this is not a problem of major cities. I saw in my region, in the Eastern Mazowsze, several thousand people going to the streets, and this is the area of Poland where the ruling party was supported by the majority, by 60 or 80% of the population. people who previously were not interested in politics also joined the protest. They didn't go to the streets in defense of the Constitutional Tribunal in 2015, nor in defense of the courts in 2017. Kaczynski mastered the forces of the whole generation of people born after 1989. This is the generation that he does not know, does not understand, and does not respect. And this is the moment when the generation experienced that a lack of democratic institutions will always end up with depriving them of civil rights and depriving them of the freedom they love so much. I dare say that, but not for the epidemic, the participants of the demonstration could perhaps go to the streets in millions. Just to finish, I would like to say that I often hear the question about how to solve the situation caused by Kaczyński in relation to abortion. Regardless of what Ms. Przyłębska decided, this is not a sentence. This is a non-existing sentence. So this is nothing to be published. That's the difference between this publication and the publication that Ms. Szydło had not been doing for months. As for the future and opportunities for abortion, I am in favor of liberalization of the law, and I think that women should have the right to decide according to their possibilities, opinion, sensitivity and conscience.
Podsumowując kilka.
So let's sum up some of the motives you have mentioned. Let's get back to Professor Sadurski. I would like to ask you, after the previous speeches, is there a kind of a turning point concerning this authoritarian populism in Poland, looking at the internal events, protests, and cheekiness of the government, and also we have this complicated and slowly moving internal domestic situation at the level of the European Union. Exactly, we cannot hear Professor Sadurski. I think that there is no turning point. I'm very skeptical when it comes to describing the turning points, because since 2015, when the anti-constitutional erosion started, I'm thinking about this rightless resolution of the parliament concerning the choice of judges for the Constitutional Tribunal. All the time we've been having turning points. All the time there are some surprising changes. Something that maybe a month ago we thought that some things could not take place, but all of a sudden we discovered that they are taking place. So in a way, we attempted to normalize, to ignore these decisions because some worse decisions are ahead. So let's not talk about the turning points. Let's rather say that we have this gradual erosion. When exposed, we are finding out that something really bad and toxic took place, which hurt the democracy. Everything you have been saying is very important. And this intensification of erosion has definitely taken place. Professor Bodnar has reminded the approaching verdicts of the Constitutional Tribunal. There have been 2 complaints submitted by the European Commission, one concerning the disciplinary system, and this decision is going to be made at the beginning of December. There's another complaint submitted concerning a law, the muzzle law, the tribunal has really played in accordance with the rules. It wasn't very happy to do that, but they did it. So it will be very interesting what will happen next, because the disciplinary system is really it's really the worst problem that is damaging the Polish judicial system. And this disciplinary system that has been adopted by the disciplinary chamber is really the worst thing. Another thing I would like to say concerning the Constitutional Tribunal, Professor and the MP Gasiuk-Pihowicz were talking about this. I just wanted to add something. After this latest verdict, I prefer to call it a communication of the 22nd of October, we can see that this is not a fake body, falsified body. It's a very active body, which has a lot of power. But instead of limiting the authority of the government in the context of infringing the constitution, well, this tribunal has turned out to be a very enthusiastic helper of the government. But behaving in this way, when the law and justice has really made this body subordinate, this party has hurt itself. Of course, the tribunal is very useful for the government to make hard decisions. I would call it colloquially to do dirty work, dirty job. Some politicians do not want to do this dirty work, but that would only be effective if a majority of people would be convinced that the tribunal is a really truly independent body of the government. Only then we would be able to blame the tribunal, not the government. But we know that the government made the tribunal totally dependent. So the protesters made this intuitive decision. They didn't go to Żucha Alice, where the tribunal is located. They were blaming the government. We've got 7 minutes left, so I would like to address one topic. So 10,000 Polish judges who, in opposition of the judges of the tribunal, are very brave. So I wanted to ask Professor Rakowska-Trela how these judges can act now when the tribunal is not dependent, and a question concerning the type of support we could provide to the judges. That second question has been directed to Kamila Gasiuk-Pihowicz and Adam Bodnar. We cannot hear Professor Rakowska. I will do my best. My mic is on, but I'm afraid we have a technical problem and we cannot hear the speaker. So we would like to have a brief conclusion.
Ja cały czas słyszę i cały czas mam włączony mikrofon. Mam nadzieję, że mnie teraz też słychać. Tak, prosimy o wypowiedź. Słychać mnie?
Yes, we can hear you. Please go ahead.
Rzeczywiście coś tam działo się. Mam 1,5 minuty. Rzeczywiście można powiedzieć, że
We can say that now the burden of guarding the rule of law and constitution is on the judges. It's a huge burden and responsibility. This is something that the judges have not been used so far. Of course, the judges should follow the law and the constitution. as a rule. But in the situation where the law is not really very consistent,
Stosowanie konstytucji nie jest taką codziennością.
application of the constitution is not a typical job for them to do. So the judges have this important task and responsibility, and I think that for the past years, most of them have been doing it very well. A great example is the court case. I have mentioned them when I was talking about the tribunal. So I'm talking about the district court in Warsaw when it filed in the year 2017 a legal question to the tribunal, and this question was frozen because the tribunal's judges had no agreement, and Ms. Przyłębska doesn't seem it appropriate to resolve this problem. So the judges refuse applying the laws that are not compliant with the constitutions. We have seen it at the beginning of this year, and this tendency is persevering. Sometimes they have more problems, sometimes less, but they are doing it. There are also other cases. Cases concerning the changing of names of streets, a case on the decision of the president of the Council of Ministers. So these are important tasks, major responsibility. They have to be brave, but judges are not officials. They guard this authority, and they have to meet up this challenge. So I'm happy that they are doing it, but to be honest, this is one of their obligations. They have to guard the third authority. Thank you. Commissioner for the Protection of Civil Rights. 1 minute from me. 3 items. Firstly, we have to be solidary with prosecutors and judges when they become the subject, the victim of disciplinary cases. So we have to be interested in these cases, we have to follow them, we have to support them. But it's also a task for journalists. Journalists shouldn't say that, well, these cases are too complex, so it's too difficult to write about them, or they are no longer important, so let's put them in the 17th page of the paper. So if they have no support, the judges will be losing their cases. Secondly, this is an issue of providing support to these lawyers, these institutions that provide support to judges and prosecutors. I mean the Committee of Defense of Justice or the free courts organizations. They know how to do it, they are great at their jobs, and they need this support. And here I'm appealing to the lawyers. It's not only about earning money in your legal offices, you have to also fight for the rule of law, and then we have to build relations with foreign judges and prosecutors. There has been a change in the United States, so I think that the transatlantic relations will be stronger. So it gives us the feeling that judges and prosecutors represent the job that should be supported, and such jobs are done in the constitutional and countries that follow the rule of law. Ladies and gentlemen, well, it will take some time before we win the parliamentary election. We know that this would be the most efficient measure to help the judges who are independent, the courts that are independent of the politicians. We have to protect them against the repercussions of the government. So this is the most efficient way, but we really have to win the election. But as I have said, we will have to wait for this for quite a while. But even now we can continue and initiate new activities to facilitate reconstruction of the institutions of the democratic rule of law. If I'm going to talk about the ongoing activities, we should provide our support to judges. We should monitor what is going on. We also know that the changes introduced by the Law and Justice Party were illegal. And everybody who appreciates the rule of law knows that you cannot use illegal means to achieve some targets. So it's like a trap. So there's a very specific area of actions using the international law. So, for example, verdicts of the European Court of Justice, verdicts on, for example, the muzzle law. So we all the time appeal to the European institutions, to the European Commission, to introduce some measures concerning this Muzzle Act. So we appeal for the fast response of the EU institutions to defend the law of Polish citizens. So issuing a verdict by the European Court of Justice for the Muzzle Act, which is so harming to the judges. It will help us to prevent repercussions against the judges. So thank you very much for your participation. So we can conclude that in this kind of politics, we need to remember that we should be interested in the rule of law in the long-term perspectives. 5 years have passed, and then we will have to rebuild the state of the rule of law. I do hope that we will analyze it more closely, and we will propose some